Okay, so again, a little show and tell here that might help some people kind of focus in on the point here so I don't have to spend as much time talking about some stuff. I get all kinds of crazy stuff these days, which comes with standing up and speaking out about things that are wrong. Doing the right thing is never easy or popular, and I have to say it is actually wildly popular now. I will say that, and that's a good lesson. Believe in the people. At first, people are like, what's going on? Ben, you're nuts. Now, Katie and I basically get asked for our autograph when we go to indoor soccer games, which damn near happened today. And that should inspire people to do the right thing, because in the end, not at the beginning, in the end, the truth comes out. So, I don't know. But typically, that's how it goes. You're going to get blasted for a long period of time. We went through that. And then people are going to get it. You just have to be sure of one thing. Make sure you're on the right side of truth. Okay? So, that's the most important part. But let me highlight this. So, let me just clear some stuff up. You got all these people. I get calls and stuff. Oh, my gosh. The family court said all these horrible things about you in this order dated April 5th, which I have in front of me. Ooh, what you got to say about that, Benny boy? Okay. Here's what I have to say about that. Whatever is in this order is probably not right for the simple reason that it was written prior to the court seeing the evidence and hearing the parties' arguments. We don't have a very good chance of getting, findings of fact correct when the findings of fact are written before the parties' factual arguments and evidence is before the court. Everybody follow that? So I don't really let me put it this way. Doesn't move me much, okay? I didn't read this for months. All I had to see, the only thing I read on here is this date. And as soon as Katie pointed that out, we knew what was in here. Bullshit, right? And I'll explain in a second. There's no other way. That's basically the point. So what's the point? April 5th is the date when this 20-page, single-spaced opinion was written. Now, I'll just show you. It also happened to be entered on the same day. That is interesting. We did a separate video on this. Katie also discovered that. We did a whole analysis of the 126 court orders. It is so weird how out of 126 times, 34 times, the weirdest thing happened. The order that blows me up, because we've spoken out about the staff attorney and what's happened down there. She's the one that writes these orders, not the judge. Those get entered right away. It takes a lot of time typically for orders to get, usually 4 or 5 days, at least in my case. But it's the darndest thing how all these special ones get entered right away. What's the hurry? Well, in this particular case, everybody knew that Katie and I were going to New York the following morning. So, as always happens in my litigation, so weird, man. Katie, so weird. You can count on the court order coming out at just the point in time where we would be maximally prejudiced by in dealing with it. This one wasn't that hard to deal with. It's the freaking date. And the house of public corruption comes tumbling down. Why then? Well, because of these dates. See that one up there? That is the date on which the parties' post-trial submissions, their closing arguments, basically, were made, containing the factual arguments and the legal arguments. Sure, we had a trial, but the court doesn't see all the evidence at the trial. There's time limitations. So it doesn't even know what the parties' arguments are in the case until their one and only opportunity to argue their facts and law to the court. And the court, and the judge, in this particular case, gave a big speech about how important these things are. And they are. They're your one and only opportunity to put your facts and law before the court. Well, ladies and gents, it was not put before the court until the evening or the afternoon at 4 o'clock of March 29th, 2021. That would be ours. Post-trial submission of Respondent Benjamin Duzing. 15 pages, dense case law, endless citations, every single thing cited in here. These are what findings of fact look like, by the way. And If the Kenton Family Court ever wants me to help them out with them, I'm happy to. No hard feelings. Okay? This is what real findings of fact look like. There's citations to the actual evidence. Here's a list of undisputed facts, okay, including the fact that the other side sent way more communications to me over the period of time than I sent to that person. Makes findings that, like, I'm domestically abusive based upon the volume of my communications seem a little bit crazy. Like, I guess the abacus is broken down there because every single one of those communications was put into the record for the specific purpose of the court taking the time to look at the evidence. And if all you have to do is look at that and say, oh, all this whiny ass stuff about how often Ben communicates is obviously bullshit, because we have all of the communications in the evidence, and there's X amount here, and there's way more than that over here. Okay, it makes any kind of conclusion that, like, like that, just mathematically stupid. And yet that is the exact conclusion that was arrived at by the court, and the justification, by the way, for denying fundamental constitutional rights. If that is scary to all of you out there who do or may have business in front of the Kenton Family Court, I would say the following. I would be fucking terrified. Okay? Take it from me. Now, don't fear. We have appellate courts. We have appellate courts for a reason. And among their functions are to make sure that family courts and lower level courts like this don't have, broken calculators. So we'll see if they can do the math. In any event, here's the other brief. You can see petitioner's closing memorandum. That's the other side's. You can see the date on that. That's March 29th, 2021, 4 o'clock. Now, let me help everybody out there with a little math. This is a calendar, okay? And as someone that has prosecuted a lot of, like, sophisticated criminal behavior, on the spectrum, I do not find this particularly clever. This is pretty easy to see right there. That is where the briefs were filed. This is when the court wrote this humdinger of a 20-page single-spaced opinion with all kinds of specific cites to evidence and all this stuff. There's 6 days. There's a problem, though. Of those 6 days, 3 are the Easter weekend, and the court was on the bench, and the author of this opinion, and the judge for that matter, otherwise accounted for during those 6 days. So really, it's 1 day. Even if it were 6, however, I think you get the point. I don't think that the court read 15 pages of some serious facts and law, and they didn't have the facts and law until March 29th. 15 pages each side, looked at the evidence, considered the parties' arguments, thought about it, consulted the law, which dictates the outcome, and wrote this big humdinger of a whatever it is in 1 day, or even 6, or even 2 weeks. It was decided in advance. And making that conclusion, while mind-blowing, a little more easier to believe is the fact that prior to the trial in the case, the lawyer on the other side told Katie that the case was, what, Katie? Decided in advance. True or false? True. So, as soon as somebody wants to come and put her under oath, she'll say that. For that matter, I was told before this litigation even began that in so many words, I felt it was a little bit stilted, that, like, I needed to do certain things, or because the person's attorney had the court, or owned the court, something like that. I confess I didn't believe that at all. But this is not fantasy right here, boys and girls. So forgive me for not being as direct about some things as I'm able to be now. You can understand that it's a little bit of a difficult thing to raise your hand and complain about cases being fixed while you have 2 ongoing litigations in front of that very court. Now, I don't know what else is being discussed. There's 10 other problems with that opinion, including there's findings of fact about things that were never discussed in the case, begging the question, where did you get that information? Because wherever it came from, it was totally inappropriate. That's like against the rules. And also the fact that, I don't know if you can see this, but everything in yellow, it's a lot of this opinion. Look at all that. Ooh. A lot of this opinion. Ooh, look at all that. I could go on and on. There's more. The yellow was literally written by the other side before the trial. How do you have findings of fact? Cut and pasted, by the way. Didn't even change it. About evidence that you haven't even seen yet. Yeah. So, as you can imagine, for all those out there not lawyers, you might think that is really effed up. And there's got to be a consequence for that. My response to that is, yeah, probably, almost certainly. My concern is not like people getting in trouble. It's reforming the system and accomplishing positive change. So that's what my focus is on. But yeah, and just judging by, well, the FBI's presence in the courtroom for the last hearing before the court decided to recuse, and also little bombshells like the fact that this entire litigation was initiated before the child in question was even born. Something that anybody can understand is a little bit curious. Why not wait until the child's born? That's a little weird. Obviously, it was an attempt to get the special judge so that the special justice could be dispensed. And it is unfortunate, though, that this attorney happened to represent affirmatively to the court, effectively lying by saying that the person initially filed a petition for custody with this court following the birth of the minor child. Well, it wasn't until October 8th, and I put the video on Facebook so all of you could see it, where the attorney got around to telling the court the truth. So, it should surprise no one that the court took that particular moment to say, ruh-roh, I want nothing to do with this litigation ever again, especially since one possible, in my view as a lawyer, likely legal outcome of that fact, the fact being that the litigation was started, was filed prior to the human life about which it was ever existing, is that the court never had jurisdiction in the first place. And hundreds of thousands of dollars of taxpayer money were pissed down the drain. Both parties spent an incredible amount of money and 2 years of their life wasting their frickin' time, all because a lawyer, a special lawyer, with special privileges at the court, courtesy of her hookup, the staff attorney that runs the place, lied her ass off. Now, look, that happened. I understand that those people who might suffer consequence because of this are not going to be happy with me for pointing it out. But in the end, them's the apples, homegirls. You made your own stew there. I don't know what's behind me, but probably is not a Medal of Honor for either of you, okay? Let's hurry this up. Feel free to step aside. Let me clean up the mess. Let's give the people a court that doesn't fix cases. Happy Saturday to y'all. Mwah!